So this talk is going to be very important for all you guys out there. IP law is actually can hurt you later if you don't pay attention to it. But so Noodle Cake has actually had a few different times that we've had to deal with it. Only one of the three that I'm going to tell you about actually was too bad, but it was a real pain. But most recently, we launched a game called The Enchanted World on Apple Arcade. And we got sent some legal papers by a company that owned the rights to use The Enchanted World in digital media. Mm-hmm. That ended up seeming like their rights didn't extend to apps and video games, but was more to websites and stuff. So luckily that one we were able to send over to Apple, and it just disappeared as far as we know. But that one could have been pretty bad for us. One that actually was a lot worse was I wasn't actually working at the company at the time, but the very first game, the game that launched Noodle Cake, Stick Golf, they got sued for using stick golf because someone else had the rights to use stick in sports games, so stick sports. And so actually as a result, that's why the later iterations of the stick golf series were called Super Stick Man Golf. And as far as I'm aware, we actually had to pay royalties. Noodle Cake had to pay royalties, had to change the name. And as part of the agreement, we actually can't make any other stick man games that are other sports other than golf. We are only allowed to make stick man golf games because of that settlement. And, you know, as a very early company, that could have been a really devastating hit.
Devastating, yeah.
And then on a lighter note, there was one of our games called Punch Quest, and in our App Store description, we said it was Chuck Norris approved. And apparently Chuck Norris actually does approve things, and they sent us a cease and desist, which we now have framed on the wall at Noodle Cake. So
signed Chuck Norris.
Yeah.
Right on.
Don't say things are Chuck Norris approved unless he actually approved them.
Unless you actually have something signed by Chuck Norris.
Yeah, exactly.
Ben, your anecdotes have led us into the beginning of this workshop. Thank you, my friend. I think we'll get started here, Joe and Ben. Good evening, everyone. Thank you for joining us tonight. First off, I would like to acknowledge that we are presenting to you tonight on the traditional lands referred to as Treaty 6 territory, and all the people here are beneficiaries of this peace and friendship treaty. This acknowledgement reaffirms our relationship with one another. So coming to you tonight from Saskatoon, I'd like to introduce myself as tonight's host. I'm Darcy McLean. I'm the Executive Director of Sask Interactive. And with me tonight is our genius of anecdotes, Mr. Benjamin Schmidt, who is Head of Publishing Technology at Noodle Cake Studios. And tonight we're the co-host for the Game Business Level Up Workshop Series. And in addition, also is Mr. Ryan Hill. He's Member Services Coordinator for Sask Interactive. And Ryan is hailing out of our Regina office tonight. He's going to keep us on track. So to get started, we have a very cool workshop, and it's presented by Mr. Joe Gill. Joe is a Saskatoon-based tech lawyer, supporting founders by providing market-focused legal advice and scalable legal solutions. And he is also a partner in McKercher Law. Joe will be presenting tonight. His workshop's called Intellectual Property Law. And it's about approximately 2 hours worth of his talk around startup ecosystems and legal considerations such as formation, trademarks, copyrights, tax matter, privacy, cybersecurity, and raising capital. But he's going to touch on a bit of those pieces. Looking totally forward to your presentation here tonight, Joe, on IP law. So without due course, let's have some good discussion, and most of all, let's have some fun. Just on a quick note, we're going to have about halfway through, we're going to have a Q&A with Joe in his webinar. And again, at the end, we'll have a 10 to 15 minute Q&A about the workshop. But you can also add in the chat feature on the presentation tonight, questions if anybody has any to raise them in the chat function. So, Joe, the virtual floor is yours. So take it away, my friend.
Thank you, Darcy, and good evening, everybody. To those of you in Saskatoon, I hope you've sufficiently dug yourself out after Snowmageddon hit earlier this week. Maybe you were as lucky as me and have a 10-foot drift in your front yard at this point, but try to look on the positive. In the midst of all that chaos, my kids were out there on what is now about a 15-foot pile of snow in the middle of my cul-de-sac, and they are overjoyed with that, whereas my back still hurts from shoveling over the past 3 days. So hope everybody's doing good. I hear there was some snow in Regina as well, but I'm not giving anybody any kudos because I don't think it was as bad. So again, I just want to thank Darcy for reaching out to present on this. I want to thank Sask Interactive for putting this together. I think we're going to have some fun. We've got some good people on here to talk about real world stories. I said before everybody joined in here, Darcy and Ben and Ryan and I were chatting, and so much gets learned through storytelling. And we are going to touch on legal concepts tonight. We're going to touch on some case study related items and everything, but nothing beats talking to people and learning from experience. And I find really when it comes to servicing my startup clients, I can tell them everything in the world in terms of bad things that may befall them, but they learn the most from chatting with other people. So separate and apart from anything tonight, we're all getting together as a community interested in a particular area. You should leverage that community, reach out to people, have conversations. It's how you're going to learn. And if nothing else, you can avoid all the screw ups that apparently Ben made. So if we're all trying to learn. I've made screw ups too. So we'll talk about all these things along the way. But I'm just going to get into this. Start sharing my screen here. Hopefully everybody will see my lovely presentation. Beautifully titled "All Your IPR Belong to Startup: Legal Issues for Video Game Startups." So we'll dive into that. As Darcy said, again, we've got a 2-hour block here. Timing out the presentation will probably content-wise end us around the hour 15 mark, which gives lots of time for questions. And I think questions are really important as we get into this. I think that's really how we unearth a lot of, the major points, and, everybody will have their own take on some of these things. So we'll go along that way. So yeah, with that said, let's start with the first important part. Important part with any lawyer presentation, of course, is a disclaimer that this is information only and should not be taken in any way as actual legal advice on how to or to not do things. You should retain. I always particularly like the one about you should retain somebody competent, which the impetus is then why am I here? If you would like to retain somebody, we'd be happy to chat about that. I think what it really goes down to is I always use it's the Google-ish disclaimer. You can go to a conference. You can Google anything you want. And there's a wealth of information on all subject matter on God's green earth, but it may not be applicable to you. And in today's day and age, it may not even be correct. So at minimum, talk to some trusted individual. If you don't chat with me, chat with somebody who's involved in the industry and knows what they're chatting about. So just more of an FYI on this. So a little bit of a background on me. Darcy provided some background. Again, just a partner at a law firm. That's the boring part. Some of the more fun things I get to do is act as the lawyer in residence for Co.Labs, which for anybody who doesn't know is the tech incubator here in Saskatoon on the Innovation Place ground. So once every Wednesday, maybe in better times, we'll see as the COVID numbers change. But typically on Wednesdays, I find myself taking my laptop and setting myself up in the founder pit at Co.Labs and doing intake hours with startups. And I love it. Laughably, my partners at the firm have been bugging me because I think I've been there more often than I've been at my office. I like my work from home arrangement. So that's been a lot of fun. I've been fortunate enough to have been doing that for a couple of years now. It's a great thing. I also act as kind of an informal advisor and supporter for Cultivator, the business incubator down in Regina. Have been down there a lot, helping out the startups working through the program as well. Again, full gamut. And in full disclosure, I've dealt with companies all the way from ideation stage where they're still kicking around the basis of an idea. I mean, even university students, first year computer science or commerce or whatever students thinking about an idea, all the way up to companies doing what we'd call Series A plus rounds, $1 million, $5 million, $10 million plus. And acquisition transactions along the way. We've been involved with a few sales of tech companies. A couple of years back, got involved with a sale of a publicly traded, maybe call it self-styled tech company located here in Saskatchewan. So we've had an interesting ride in terms of experience. Also serve as a board member. Ideas Inc., for anybody who's not in Saskatoon, is just another business incubator, not tech focused, but again, deals with entrepreneurs. Counsel to a whole whack load of tech startups at all different phases throughout Saskatchewan and the Prairie provinces, actually. We got a few in Manitoba and Alberta. And more entertaining is I did try my hand at 2018 at co-founding a tech company. That lasted for about 9 months. I thought I could revolutionize the interaction points between lawyers and clients to a more lawyer-client portal, as opposed to just sending documents through email, and maybe have a more interactive experience. So I tried my hat at that for a long time, or for about 8 months. Had a long overdue conversation with my wife about risk, and then summarily, put my tail between my legs, and here I am, sadly stuck as a lawyer now. But it was it was a fun ride. I have actually pitched investors. I've gone through the motions on a few things like that. So it was a great experience. I really enjoy it. I still get together with my co-founder probably every 2 weeks just to talk about random things and relive all my terrible pitches in the early days. So little bit of background on me from that side of it. The other thing I'll say, just relevant to this, I think I was particularly drawn to this in that if you went back and looked over the history of my youth, I'd say video games actually played a fairly big part in that. I think I had my first video gaming system when I was 3 or 4. It was a Sega Genesis. And, initial run of Sonic the Hedgehog was kind of the first game that I can, in my mind, conceptualize and whatnot. I also, for some reason, remember acquiring a Game Shark and then breaking the game summarily with the number of cheat codes I kept trying to ram in there. So, long time thing. And actually, while I was preparing for this, Darcy, I didn't even mention this, but I found, I was reaching out to my mother, and I think it was grade 4, grade 5, as people are ought to do, of what do you want to be when you grow up? And I actually wrote a paper on saying I wanted to be a video game, I said video game storyteller. And I was interested in, writing the stories and the narratives associated with it. And, I could even think during high school, I thought I was actually going to do computer science, and then somebody convinced me to follow down the law path. And, again, we all make terrible decisions in life.
Joe, your mother did tell me that story, and I didn't want to embarrass you.
It's a great story. I'm very happy with it. But again, it underscores, I think these are an important medium. They tell great stories. They tell grand stories. They brought, lots of people together. I was not a fan favorite with the ladies in high school, but I had lots of great memories of Halo LAN parties in a friend's house where we connected up about 4 different TVs and Xboxes in different parts of the house, and, played original Halo until one jerk of a friend of mine decided to walk over to the router and blow it up before we'd kick his ass. But hey, I turned out better. So there's karma in life. So anyways, with that table set of, what you're getting into for the purposes of this, let's talk
Awesome.
about IP. So intellectual property. I have a link up here, the Canadian Intellectual Property Office. And look, I want to be very clear with everybody. These presentations, I think, are the way I always conceptualize it with people who aren't experts is we want to empower you to at least spot issues. It's not the notion that you will have a deep unparalleled understanding of the nuances of copyright or trademark. But like, Ben was kind of illustrating with his stories, you hope to learn from mistakes and maybe recognize when the train is incoming and whatnot. And so I think that's really the important part of, when we talk about, in the legal world, we call it issue spotting. You want to be able to at least go through, your journey as a game developer and maybe recognize that, hey, this is something where I should have a conversation with somebody. That's kind of the key. I mean, again, one of the reasons I put this slide up here on the first part, the Canadian Intellectual Property Office, great website to just spend some time if you want a primer on a lot of this stuff. Most acutely, and we'll talk about this on subsequent slides, is it's a great place for searches. Ben talked about some great examples of, getting ugly cease and desist letters because you thought that, maybe thought that that idea was not covered. Nobody else had stepped into the space. Nobody else had registered a copyright, a trademark, or something like that. I mean, I get clients of all tech startups that I serve to spend time on this website doing trademark and copyright, and depending on if they're into more of the hardware side, patent related searches, because there's a lot of stuff out there and you don't want to spend a huge amount of time only to find out you've run up against somebody else's IP. Like Ben's story kind of indicated, there can be nuance. I mean, there can be space for both parties to exist. I sort of always think it's not a video game example, but I like using it because it's very Saskatoonian. The fun trademark dispute from years ago between the guy who makes Hanes hummus, which, if anybody doesn't know what that is, quick plug for that stuff. It's delicious. Go find it. Hanes, Hanes, hummus. I'll get my royalty check later. And Hanes, the underwear manufacturer. And the underwear guys were not happy about the use of that name. Leave it to your imagination to try and draw a link between underwear and hummus/chickpeas. I'm sure some people can. If that's you, that's acceptable. But the point is after many hilarious letters written back and forth, our underdog Dave, our local guy here, ended up prevailing on that because, of course, hummus does have nothing to do with underwear, and the name Hanes was his nickname. So, again, just a point on that side. So when we look at this slide here, this is kind of the overview of IP as a whole. And you've got kind of these 5 heads of different types of IP: patents, industrial designs, copyrights, trademarks, and trade secrets. And what I've laid out here as well is just some kind of high level things. How hard is it to get? How long does it last? What does it kind of cover? And what are some general examples? We'll go to a slide in a second here that drills this down more to the video game section. But I think it's just important to note that this is kind of the universe you're dealing in. And, the first slide is really an important theme. And I'm going to hit on this at the end as well, that, there are any level of services and protections you can acquire when the time is right, between bronze and platinum coverage. And if you had all the money in the world, you might go straight to getting platinum coverage and filing all sorts of registrations left, right, and center. But again, most founders I know are adopting a very lean startup. And so it's a choice. There will have to be trade-offs you make at certain times, and points in the journey where it makes sense to go and pursue something more extensive, like perhaps a full patent application, which is, at least if you can tell from the little dollar signs, ends up costing the most out of these. But also key to note, and you kind of see that when we talk about copyright and trademark there, those can be free. There are a few that arise just from the nature of use. The general rule is registration always gives you some better protections. But again, I think the failing sometimes with advisors is we say, of course you have to do this because it's the best protection, but it's situational. And again, not all of you are going to have unlimited funds to pursue all of these things. So some of this, and we're going to talk about a slide later on that, are just making important choices based on the level of the journey you're at. I mean, I find myself in tech, for instance, framing my advice more along raise round series. Are you an ideation stage company? Are you a pre-seed company, a seed round company, a series A company, and whatnot? That, I think, does a better job of linking what should I actually care about now, versus just trying to talk about it in general terms. The point I'll just make on this slide too, we're not going to go through all the different things, is just when it comes to generally for the world of video games, copyright, trademark, and trade secret are going to be really your friends. Copyright, kind of primarily the most important, trademark next. Trade secret's kind of an interesting beast because you don't register it. It's just top secret things you don't tell people or the other parts of the world. Patents we are going to talk about, but they're really going to have more of an application when it comes to peripherals, hardware related plays, as opposed to just purely on the video game side. And what I get at that too. Oh, and sorry, the other thing I should have mentioned with this link, I don't have it linked as well, but obviously, as you can anticipate, I think most people, when they're building these things, they have global domination aspirations. So please, 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 I know it's a hot mess right now, but the United States is still a big old market. So you're probably well served to go and look at the US Patent and Trademark Office's website and do a similar kind of rundown. Because if Americans are known for one thing, they sue people. So watch out. And as we're going to get into later, the Japanese as well. But just another point to raise. I'm going to advance here. Sorry, guys, it's got a little bit of a lag. Okay, so in the context of video games, because let's drill this down. So again, you can kind of see I've started organizing things based on the different heads we're talking about and the different types of stuff. So we talk about copyright, for instance. We're talking about music, code, the story, the characters, the art, the box design, and the website design. Trade secrets, things like your mailing lists, your pricing information, contacts, more contacts, maybe some of your in-house development tools, even deal terms, the particular deals and negotiations you've struck with other parties. You may want to keep close to the chest because knowledge is power after all. Trademark, obviously things such as your company name, your logo, your game title, subtitle, and identifiable catchphrases perhaps associated with the game. I will not attempt to butcher Mario's signature catchphrase. I don't need that recorded. Patent, hardware technical solutions, inventive gameplay or game design elements, and some technical information such as elements in the software and networking or design. I mean, the key, and we're going to get to this over and over again, is look, IP is somewhat of the lifeblood of this industry, and it's associated with both the tools used to develop the games and the content included in it. I will raise at this point a question that everybody can kind of consider along the way, and we'll touch on it more with the slides when I get to mods. But this, I almost call it a bit of an ongoing tension with, say, the support of open source. Like, should you create something for the people, democratize it, and allow it to take on a life of its own organically, and deal with just the will of the creators who are willing to build upon it, and nobody sort of owns it. Again, people have to make money at a certain point, so I'm not completely in favor of that. But it's this interesting concept, and separate and apart from the video game concept, I've seen this used as a almost a strategic strategy of sorts. In that, do you just build something on an open source basis, release it to mass consumption, and generate such early adoption because it is so freely available, and then you build a better mousetrap on top of that, knowing that you can hopefully convert your tribe that you created to a paying solution afterwards. So there are conversations around that. Obviously, there's nothing set in stone, but it's something to consider as you go along the way. As I mentioned before, in terms of order of priority for video games, it's really copyright, trademark, trade secret, and then patent. And we're going to deal with those in turn. So I'm going to jump into copyrights here. So traditional kind of definition here. What is copyright? Well, it's the exclusive right to produce or reproduce a work in whole or in part in any form in a specific country for a specific period of time. And in Canada, it lasts as long as the author who made it is alive, plus 50 years, 70 years in the US. And again, we touched on that in the other slide in terms of there are examples of this. Stories, characters, music and videos, graphics, the environment that you're in. From a how it gets implemented standpoint, we of course have laws in this country. It's a federal piece of legislation called the Copyright Act. That's what really puts this in place. You'll want to know too, again, I won't go down the rabbit hole on this because it's really a legal point that only a lawyer could love on this, but you'll sometimes see this term called common law rights. And what that really means is that we know there are courts. So within courts, people come to court, they fight with each other, and judges interpret the law. There is a body of laws out there that were made by judges. And some of this honestly dates back to as far as before Canada was a country, and we imported it from UK-based law. Again, most of the newer stuff dealing with this, we're not going back to the 18th century to deal with video game related disputes, obviously. But I reference it because it comes up at times, and people do talk about, common law versus registered rights. And, in a situation like this, common law can occur really as soon as you've fixed your expression in a medium, like it's in code or it's print, or even saved it to an art file or something like that. And, this kind of gets at one of the core things to take away with copyright is it protects your expression of ideas, not the idea itself. And what, again, that leads to is, look, no game ideas are protected by copyright until they're fixed into some medium, like I just discussed. And similar ideas expressed in different ways are still allowable under copyright. That's what kind of gives rise to seemingly some wiggle room when, Ben brought up that story initially when we talked about, maybe not stick golf, but enchanted forest in a different context and whatnot. When it comes to dovetailing on that, when we talk about infringement and nasty letters from people and whatnot, you basically need to compare that expression in the copyrighted game to the expression that the infringer has. I mean, it's not an easy task. The big key too is knowing that it's on you as the party that owns it to enforce. Like, you don't call the cops and get them to enforce your copyright or any of your IP rights. So it is on you. And I mean, I'll make another point. It's going to come up here over and over again that if you are going to loosely play on content generated from certain parties, you should be very aware whether those parties like to sue people or not. And we're going to touch on which parties are, perhaps more litigious than others as we get into this, but that can be important. Real key point here, though, just kind of getting back to the cost saving thing, copyright arises as soon as you create something. As soon as the plans are drawn or the code's written, arguably copyright is present. In most cases, you do not need to, well, let me just say this. You do not need to register, but you get better rights if you do. There are more statutory, we'll call that legal rights under the laws in Canada that are afforded to you if you register. But again, I want to go back to that earlier point I made. Not every company is going to be in the position to necessarily pay for that at a point in time. But to give you some comfort, as soon as you've actually fixed it somewhere, it does arise. Public domain is more just an interesting point about some things are so old that they belong to history itself. So, historical characters or something. Robin Hood, fairy tales, Mount Olympus, the concept of hell and whatnot. These are things from great art or literature, generally from the 19th century and whatnot. They are so out there in the public domain that there's no real way for somebody to claim ownership over them. So you can rightfully use something that falls into that category without necessarily worrying what you bump up on it. You just have to watch that you're not necessarily ripping off the same storyline. So a good example is like two companies can exist by leveraging the same historical events, such as wars. Battlefield and Call of Duty both use tanks, weapons, uniforms that are historically accurate, and they don't infringe each other. But you have to watch for stories inspired by historical events. So I say you can't rip off and build the video game Saving Private Ryan, but you could make a game about the Normandy landing, as long as you're not actually taking the story itself. So this is more like, I know sometimes I've had clients say, well, I can't do anything. Everything good's already been invented. Well, not quite. Like, it is about that special mix as you kind of build things along the way. What I've got here, just to kind of drive an example home, is when I pulled off the that website, the Canadian Intellectual Property Office website. Couldn't help myself, picked Mario. So this kind of just illustrates some points about, look, copyright can exist in a number of different mediums, and you see different registration dates on these. You've got a generic registration here with just Mario, then there's Mario Tennis, Mario Story, Mario Clash. I didn't have enough page. I could have filled up probably 50 pages of Mario related copyrights. But the point is going back to my point about the way that things morph and ebb and flow. They couldn't have just put down Mario and been done with it. Like, it is on you to be assertive about the evolution of your work as well. And so if your work does take on a different concept and whatnot, you do have to go back, and kind of is a, proactive strategy when it comes to development of your creative works. You can't just assume again, you cannot just assume I did it once and that is good for all time. New iterations need to keep being built up. Again, subject to funding, your ability to do so, all that other stuff. But again, because this is really protecting kind of the main guts of game design, it is one of the more important items here. The next one that I would say, remember, copyright does arise from use, but trade secret is another one that we often see, and we see it used quite a bit with early stage innovative companies that don't have the wherewithal to pay for, say, formal IP registration. So trade secrets are basically again, broad definition here, anything that may be used for business advantage that a company keeps secret. As long as it gives you some business advantage and you don't talk about it, it's a trade secret. We don't have a particular piece of law out there like the US does that talks about trade secrets, but I mean, these are, some companies adopt a we don't register our IP standpoint. We just develop a better mousetrap than everybody else. We don't talk about it, and we will rely upon the fact it is kept confidential to secure this. The most famous example that always gets used in any presentation on trade secrets is the Coca-Cola recipe. I should got to be careful saying the Coke recipe. Coca-Cola has never registered anything associated with how they make the beverage. They just apparently have it under lock and key. I think the current KFC recipe is a similar one on this type of it. Again, the dangers you run with this, of course, is if it gets out of the hermetically sealed chamber that it exists within, all bets are off. Like, as soon as it gets out in the ecosystem, you may try to take runs at it in other forms, but you didn't protect it. And I mean, that is why a big thing I reference here on this slide is, and I think this is just good practice in the early days, and I'll reference this again on another slide about best practices, is, you have to be proactive. You need to look at things like passwords and encryption over that information that you're creating. You want people locked up under employment agreements, non-disclosure agreements, or at least assignment of IP rights style agreements when they join your team. Otherwise, it's just the wild west of rights. I said locked cabinets in a quaint overture to when we actually all did things physically, I guess. Again, as I said, good choice for early development. No cost to do it. It just kind of arises. And I mean, I bring up a few examples here about like an in-house development tool to make a 3D level with objects, a mailing list for subscribers on an MMO, or even the terms of contracts and licenses that you enter into. Again, it's the disadvantage is either somebody reverse engineers it or they just discover it. Independent discovery is another way that this could occur as well. So if you are truly worried about something, you may want to proceed to registration. I'll just add the other anecdote too, that, if you are a, what we might call a venture scale or a company looking at acquiring investment, having a robust IP portfolio can often be a make or break when securing investment. So again, you may be able to placate some investors with the concept of, well, we have everybody under lock and key and it's a trade secret, but there are other ones who will actually want to see you, go and formally register, copyright, trademark, all these other points. And again, that can be situational. So moving into trademark. So again, legal definition here: exclusive right to use a mark on specific goods or services and prevent others from using a confusingly similar mark. So this is really, in the hierarchy, I would say the second most IP right, since a good trademark could set a company and the game apart from its competitors. A lot of people will probably be familiar with how it's kind of denoted. They see the little TM or the R in a circle in superscript associated with things. That's actually tying back to my little blurb that I went on about common law versus registered rights. So, you can put a TM on anything that you're trying to assert common law, non-registered sort of rights over. And if you've actually registered a trademark, you can put your little R on this along the way. And again, those can be continuously refreshed, because if you pay attention where those pop up, and even just like ads and that type of thing, I mean, they'll be our, it'll go year by year, 2019, 2020 across the way. And again, we talked on the first slide, they can last for a period of time, but depending on the size of the company, some take proactive steps, particularly if it evolves. And I'll make a point about that in a sec. So they do come into being when a company uses them to identify products and services. So quite frankly, you create that awesome design and you start using it in the marketplace. That's your first birthplace of your trademark. There is a formal registration process for doing so, but kind of like we were talking about with copyright, it can just arise by use. It is really only protected in the area where it is used, which again, nebulous concept because most tech, video game, et cetera companies, they may be geographically bound maybe by their workforce or something, but again, this is going to be spread out over a wide swath of users, players, et cetera, in a number of different markets. Again, like I say in the slide here, protection matters if the mark is distinctive. So again, this is one of those things that hopefully goes without saying is you need to create something that stands out. Separate and apart from the legal requirements on this, if you don't have a distinctive mark and you don't set yourself apart in the marketplace, you're going to have a hard time generating traction. I know investors may have issues with that as well. I raise the importance here again that I keep harping on about searching IP registries. Don't go out and think you have the greatest mark ever for some particular company name and it took me 5 seconds to go put the company name in the trademark search and there's 80 different people who already are using that name. You may want to revisit it, particularly in the early stages, because I know it's tough. Like I can think of one example. It wasn't tech, where a founder had been using a particular name and had developed a lot of good traction here in Saskatchewan and a little bit in Alberta as well. And unfortunately had never really conducted any meaningful trademark search. And it turns out there was a company that was almost identical to this one, operating in BC, and more critically had been operating for a lot longer than this company. And again, I tend to think if that had popped up earlier, there might have been a pivot. It's a tougher thing once the train has left the station and you've got the inertia and the momentum of your startup behind you. So again, searches, very, very important. Actually, a good example on this point is with Microsoft. So prior to launching the Xbox trademark was actually in use by another publicly traded software company. And Microsoft didn't notice that, which I think by all accounts, an easy trademark search would have disclosed that fact. And so apparently that was eventually settled out of court, but maybe dovetailing into Ben's story at the front end of this is there were payments made as part of that, is what I'm told. So again, you can, and what's the old saying? An ounce of prevention is worth a pound of cure. So be proactive. My last point here just lists some particular examples of trademark, names and logos, graphics, short phrases, catchphrases, even things that have, sounds odd, but smells, sounds, and colors, rarely though, have been on there. Game titles, another important one. The next slide kind of drives home this importance of like, pick something good and pick something memorable, maybe is how I would almost phrase it. So, this is kind of an idea of strength. So, if something is, it kind of goes from best to worst, if you just kind of go from top to bottom in terms of, is the mark what we call fanciful versus is it just generic? And, fanciful is getting into, look, it has no meaning beyond the one given by the company. Like NVIDIA is just NVIDIA. It doesn't have a norm anywhere else. Arbitrary, again, words previously unassociated with something like Apple. Obviously, apples exist aside from Apple, the software company, but it's been so, delineated in the, software or hardware related realms that is probably your next strongest. Suggestive is, again, like the name says, suggests something about the source. So Electronic Arts, a PlayStation, Sonic the Hedgehog, and I kind of put the generic descriptors in there. They're weaker, but they're still registrable, meaning you could probably still get a trademark on those. And then you get into the ones where they're just crappy, to put it bluntly. It's either descriptive, it really just says what it does. Like if you have a computer store called Computerland, that's pretty weak, unless you were used very extensively. And I think that's kind of the key on it, is if you could develop such attraction on it, and this kind of gets into the category, and I'll get the technical term wrong. Effectively, when your product becomes synonymous with the name for it, I don't know why I always use Kleenex, but I mean Google kind of operates that basically in the search functionality area. And then generic, like if you just called something video game, like you're not getting any protection associated with that. So takeaway here is, try to pick something good. I know you will always want to maybe incorporate elements, and I have been in rooms with people trying to come up with hilarious names for their startups, which is kind of part deliberate marketing strategy and part arcane magic. If I did it under the guise of the two guys who run the Co.Labs business incubator right now, Jordan Duchek and Alex Shimla, and I will admittedly say there was a very detailed structure for picking a name. This was when I was doing my legal tech startup. It did also involve copious wine while we were doing this. So, but we did come up with came with something that seemed okay at the end of the day. So again, it's the more unique you can be, the more protection you're going to accrue to yourself. Just on the next slide here, again, I think sometimes, seeing what it actually looks like. This is pulled directly from the Canadian Intellectual Property Office website. It's the trademark just listed as Super Mario. And you can tell it's in relation to, again, Mario, but in the context of household garments and other stuff. So there's bed sheets, blankets, throws, comforters, bath mats, towels, footwear, Halloween costumes, infant and toddler one-piece clothing. Again, you can see how it's getting linked to a particular use case by virtue of these things. And again, if I had pulled there were other ones as well. We'll have a running theme where Nintendo tends to be very proactive in this marketplace with a few things. So, if you want to see a lot of these examples, you will find a lot of Mario related examples under trademark copyright and other ones as well. But I just wanted to continue the theme and show you this in terms of, and you get some basic information too, like when was it filed, when was it registered, when does it expire, all that other stuff along the way. So just a lot of the stuff can go in. Sometimes, quite frankly, maybe it's only a weird lawyer thing. I remember back to my intellectual property class in law school, and we probably spent the first 15 minutes of every class. My professor would pull up the intellectual property office website, and people would just yell out stupid things to put in to see if somebody had, tried to seek a patent or a trademark on something. Go and do that. It is quite fun. You will find Death Star. If you look, you will find it. Somebody has tried to do it. I won't say in what medium, but lasers are also a fun one to go and look up, just to see what ridiculous things people have tried to seek IP protection on. But again, can be fun. But more importantly, it's about making sure you're not walking into a problem. And we'll also touch here on patents. Again, not as frequent owing to the use that most game applications don't particularly in and of themselves satisfy the subject matter criteria of a practical application. And that's more getting into, again, I would trade it up as hardware, peripherals. I mean, I give some examples there in the final column of, computer hardware, devices, circuits, something with technical effect or inventive. I should actually say inventive, sorry, not incentive, but inventive gameplay. A good example, I don't actually know if it's patented off the top of my head, would be, people of a certain vintage will remember Duck Hunter and on the original NES, and, the gun may have been something that actually could have been subject to a patent as a peripheral. Racing wheels for games are another one that could sort of build in. There's actually lots of patents floating around there for, new and fun takes on the traditional gaming controller as another kind of item out there. So I know we were kind of focusing on video game development, but sometimes that can be obviously a strategy. I mean, clearly a racing game, Forza or something, wants to sell you on both the game package as well as the specific and unique way to go about playing that game. If for no other reason than to just, they'll charge you more money charging you for the game as well as the peripheral. And again, really when we get into patents, as it says here, exclusive right to manufacture, use, import, and sell the invention. You get a monopoly on it for 20 years, dealing with the structural and functional aspects of it. I lay out here some of the criteria of patents. I think just for the purposes of tonight's presentation, we could go down a rabbit hole of all the various pieces of it, but just because it doesn't come up as much, I'm not going to spend as much time on it. I should have referenced as well. I'll just quickly go back here. There was a link that I think let slide by, and I didn't actually say anything about it. Just on this slide right here. So this link right here is actually the World Intellectual Property Organization published it's a long read, so I don't actually expect many people to rip through it, but it's a great paper summarizing kind of the global status of IP rights vis-a-vis video games. And more importantly, that website, and I'll reference it later, again, the World Intellectual Property Office, has a lot of good material on it, and sometimes can be an indication of where things are going more than where they are today. So they will publish thought pieces, other sorts of things along the way. But I do recommend if somebody wants a more deep dive on pretty much all the content we're talking about here, that link is something you should definitely check out when you have some time, or maybe if you just have a hard case of insomnia. It is actually written in a relatively user-friendly way, but again, maybe you shouldn't take my word for it. I read awful stuff all day, every day. This is an example of when you pull up a patent on the Canadian Intellectual Property Office website or the US one, you get a lot of different tabs you can sort of click on that provide different pieces of information. I picked the fun one, which is the design tab. So you have to actually draw out what you're talking about. So this literally shows up as unlocking secrets to video games is the name of the patent. I personally found that hilariously generic. And as you can see here, a very generic description, a method of enabling extra features of a video game based upon a type of controller used to play the video game, the method comprising the game controller with information. I mean, this seems to actually just describe a game controller in a very generic sense. But part of the reason I also picked this one is to show you that, look, the holder of this patent is not getting royalties from every video game purveyor on Earth. Showing you that you can seemingly wander across something that at first glance you go, well, somebody already patented the idea to controllers, so I'm screwed. That's not how it operates. And that's why when you look at these things, and I didn't have enough space on the slide here, they're very nuanced. Like patent applications get very nuanced. They are very difficult to DIY. And I say that because I've had clients who have tried to DIY copyright and trademark claims. And again, we always prefer that you hire an expert. Again, should have been transparent about this on the front end as well. I am not a registered patent or trademark agent. I know a lot about this stuff, and clearly enough to be dangerous on this. I actually work closely with another lawyer out of Regina when I have to pursue those. But patents particularly, they're one area where you really need to be in the thick of it to be able to get this right. It's as much having an engineering degree as it is a law degree when filling these out. So again, just a quick little segue on those. So then we kind of get into the practical side, which is more, again, we gave the background, but I don't actually expect anybody to know the quick legal tenets of some of these areas. So, what do I do? Like, I'm building a game or I'm starting a company or something like that. What can I practically actually do? So, I mean, the first one is think about good protection measures. Like if you're bringing people, if it's more than a one man or one woman team, like you will want to think about how are you keeping information confidential, or do you have an agreement among the three people who are working on this? Where are you actually storing the code? Where are you storing the design art? Are you limiting access to it? Like it might be fun to show friends, but that might actually cause you harm later if it kind of squeaks out into the public domain before you get a registration on it. And keep a good record of ownership and development. Like startups are chaotic at times, and you may have different team members come in and out. You do not want to find yourself in the scenario years down the line where you've got great adoption of this and somebody pops out of the woodwork and they're like, I worked on the early iteration of Stickman, give me my money. And you're like, but we signed you up on stuff. Like you're subject, and you hopefully at that point say you signed an NDA and you signed over your life to us when you started working for us. So, bye-bye type of thing. But that's not always the case. And I think particularly when I see with my startup clients, they're so eager to move with velocity that some of this stuff gets left to the wayside, or they try to do it after the fact, which again, you can do, it's not recommended, but again, just some consideration on that. I said here too, I've harped on it over and over again. Do your home. I mean, I should have renamed that second box there from run searches to do your homework. Like if you have a great idea, make sure it is a great idea. Like I've shown in the stuff we've talked about, it can be close. Like I don't. You could make an argument that there's no truly innovative ideas. Everything kind of builds upon things and finding them in a new way. I've explained this at times as I have a bad habit of times to de-stress. I watch the Food Network, and every now and again they have a show called Chopped, where essentially, if me and Ben and Darcy and Ryan were playing this, we'd all be given a basket of random things, one detestable thing that nobody would ever want to cook with, and we have about 30 minutes to 45 minutes to make a great meal out of this in conjunction with some other stuff. And the winner is the person who takes the stuff that already exists and builds it out in the best and most unique and, of course, appetizing way. And I think it's a good analogy because, we all started with the exact same stuff. It could have been, some flour, some sugar, some milk, a cockroach, and a, can of Big Bear. And again, you gotta do with that. And whoever comes out and pulls that together may make something greater than the sum of the parts along the way. But it also kind of underscores a second key point of IP is that it's sometimes a soup. Like go make cookies and then tell me where the flour is at the end. Like you mixed it all together, There's a whole issue we're not even going to get into on this slide, or not in this presentation, dealing with like collaboration and IP rights of joint ownership and collaboration. That could be a mess. Because you're trying to say, me and Ben may sit in a room and come up with some great ideas as we're whiteboarding something out, and then we kind of all slam them together and create the end product. Well, we know what the end product is, but if we're trying to fight about which portion of our ideas found themselves in the middle there, that's difficult. That is not an easy way to trace things. And so I talk about that ownership thing. So do your homework. There are publicly available sources. Like just do a Google search. Being candid, nothing infuriates me more than when I get a new client and they say, I can't put this new name in this new thing. And I'm literally on the Zoom call with them and I'm 5 minutes into it, just doing a Google search. And I'm going, yeah, and there's these guys. Like that shouldn't stop you. I like companies that will try and tackle giants. But if you didn't know about it when you got on our first call, you got to do some homework. I make another point too about, look, once you get to a certain size, green light your fans. Like you can create packages with material, conditions for using it. We're going to talk about this on a slide on mods, but you want to let your tribe know that it is acceptable to use your stuff and the manner in which they can, either modify it or use it in their own kind of medium and that type of stuff. Again, we're going to talk about differential viewpoints on that in a second here. But if you are going to establish a fandom and really maybe adopt that kind of open source mentality that we were talking about on the front end, you want to let people know that it's okay. A lot of people may not care. There's definitely a lot of people who have never read the terms of service for any site they've ever used. But there are embedded things in there. And my last one is, look, you got to make it, and you got to make it unique. I said this already. We looked at that chart about fanciful, arbitrary. Pick something good. It's tough. It is a tough thing to come up with something good. It is okay to start with something bad and grow into something. That's literally called, this is pivots in the startup world. You start in one area, you learn and you move, you try something out, you get some initial test players, test users associated with your product, your game and whatnot. You realize everybody hates this particular feature. You scrap it, you change the name, you go back, reverse. It is a game of iterations along the way, and that is okay. You will not get it right the first time. Even if it's the greatest idea on earth, it can always be improved. And then just some other points here about, understanding related legal agreements. I'm going to talk about this in the second slide. There are terms to understand on some of these things. What I typically say too, one of the benefits, the internet is a cesspool of many things, but it's never been easier to find kind of anecdotal blog posts or more what I would call founder focused literature when it comes to things like related legal agreements. Like if you just do some base Googling on, publishing agreements, video games, you'll find actually a bunch of good TechCrunch articles that deal with this and really take more of a founder focus as opposed to boring lawyer guy focus on things you should care about when you're engaging in these things. Obviously, you're going to I shouldn't say obviously, hopefully you end up paying some professional to help you out with that. But you kind of got to be aware of, where could you really go off the rails? And my final one is, you got to adopt a lean approach to IP registration. You don't have probably an unlimited amount of money to pursue everything under the sun. And I said this before. So, you may have to focus on particular things and leave other things. Like copyright and trademark can arise just from use. Maybe once you get enough money and you can pay for a registration, copyright may be the top of mind one there. Trademark. If you're building out a related hardware application, you may have to tackle the patent later. It's a longer process. It's a more expensive process, as much as that better video game controller seems like something that you should go in there. Growing internationally at a measured pace. This goes beyond IP. We're going to touch on a later slide kind of quickly on privacy and related matters, but I know that's a danger of too much growth. Different countries have different laws. And as much as it seems it's easy to say, well, I'm complying here and, I generally am complying in the US, so I'll go just anywhere I want. That can be folly. Again, data privacy is a big one. Europe is the most restrictive regime by far when it comes to data privacy related laws. And some of it could just happen organically. I had a conversation with a client of mine 2 weeks ago. They're a tech startup out of the Regina area. They weirdly developed a big following of users in Belgium about a month ago. And we have no idea why, but we then had a call with a Belgian privacy law lawyer about everybody's favorite boogeyman term, if you hadn't heard about it, GDPR. Nobody likes GDPR. Literally, there's a whole strategy around. In the beginning, I think, at least when it first came out, it was, well, sorry, you have a European IP, can't help you. That was, I think, the strategy for a while, avoiding it, where this is not a presentation to get into GDPR. We would need much longer amount of time and probably an EU-based lawyer to talk about it. But just watch out. Again, it's easy in the digital realm to move across borders without thinking about the implications of doing so. You shouldn't let that scare you from growth. I think global growth is good. As I said, I like companies hell-bent on world domination, but you got to watch for it. And, ensure everybody has, they understand IP rights. And I think really I'd phrase that last one as, if you're operating in a team, make sure everybody understands the rules of the tribe. Like, let everybody know that, look, we've incorporated a company, for instance, we're going to develop all this stuff as we create the next sweetest game out there. And it belongs to the company. It doesn't belong to us. We all signed IP assignments, employment agreements, all this other stuff. I'm not going to come back later and say I withheld, the secret sauce so that I can hold you all over a barrel at some point later on. So that's part of an important point, I think, I see strife among co-founders of startups because they fail to have a consistent set of rules of engagement. Nobody sat down and actually talked about what happens with ownership of the stuff we create, which probably should just be in the company, and then you can agree on who owns what percentage of the company. So a key point on that. I do have a slide here on dealing with publishers, just being cognizant of the time. I might leave these concepts to maybe Ben's pointing out, maybe he wants me to talk about it. So I have a bunch of points on this. Look, like any good negotiation, understand forms and negotiating levers. I think the big one from the front end is you should do your, again, this is a theme, do your homework, vet them. What games have they published and how well did that do? Do they have capabilities to distribute in the marketplace, the type of game, and the resources to market, distribute, and exploit your game? Do they use sub-distributors? When you talk with other people, talk about, referrals. Were other people satisfied with them? How easy or difficult was it to work with them? What type of milestone approval processes do they use? More importantly, what do they have as financial resources to be able to actually do the things they're telling you to do? And, what kind of relationships do they have as well? You're also hiring these people because you might need connections with console manufacturers, retails, mobile marketplaces, and whatnot, as far as the vetting side of it. I could go down the rabbit hole on like different points on the actual publisher agreement itself and the way that kind of ebbs and flows from a negotiating standpoint. Big ones I'll just hitch on quickly. Ownership can obviously be a key one. You as the person who brought the baby into the world, the developer will probably want to retain ownership. But if that publisher is financing the whole project, or the project relates to something that the publisher already had in the kitty and you're just improving upon it, then they're likely going to get ownership. It's sort of like my father had a saying that I'm pretty sure he appropriated, and it's probably from some other place, that the golden rule is he who has the gold makes the rules. And that tends to follow very true when we talk about legal documents of any particular size. Consider too, on the ownership side, the implications if there are follow-on games. I mean, sequels are rampant. If you're developing any sports game, guess what? It's going to be the 2021 version of, we've had Madden without fail for years and years and years. So you can kind of tell. I think everybody wants to continue building on, and more games have moved to that. I mean, there's lots of literature out there lamenting the fact that movie studios only develop, trilogy style movies now. But that's a point you might want to consider along the way. And then from the financial side, look, that publisher wants to get their money back, and they probably want to recoup the money they put in before the developer makes any royalties on that. That's just more of understanding a timing perspective. They are going to put some fuel in the rocket ship to get it going. If they're doing that, and that's true of most financiers, there's going to be a general expectation that they put first dollar in, they want first dollar out. I mean, you can have negotiations to make sure you don't starve, but you need to understand that it's not going to be as much as you think you brought equal power to that. You may be disappointed if you think you're getting into some type of 50-50 split in the beginning or something. So there's a few points on that. The thing I'll say too, just there's a very extensive part of that World Intellectual Property Organization paper I referenced that talks about this and gets into kind of the nitty gritty of different points in a publishing agreement and negotiating levers and whatnot. If you do find yourself in that situation, definitely spend reading that. This one.
Joe.
Oh, yeah. Go ahead, Darcy.
It's 8 o'clock. We're kind of halfway through. Are you at a certain point where you could maybe screen a couple questions, or did you want to kind of continue and have a Q&A at the end, or what's your thoughts there?
Yeah, so I just have 2 more slides here on the IP portion, and it'd probably be another 5 minutes, and then we could cut it there and then deal with the other stuff, if that sounds good.
Yep. Okay, let's do that.
Perfect.
I'll just say real quick, I think Jason next week might talk more about publishing stuff and publisher agreements. So if you're interested in hearing more about that, come next week as well.
Right.
Perfect. So mods, I kind of drew the distinction in the world, maybe view on this one of, North American view. Mods are fine if they're helpful. I probably should have written that. Mods are fine if they're lucrative. The Japanese view is more games are art and you can't mess with art. And this is an interesting one. I mean, I want to frame this as, look, it still comes down to copyright law and the points we were talking about before. But, there's almost a cultural difference in the way video games are viewed between, North America and Japan. And when we talk about North America, it's more the commercial value takes precedence over the artistic value. There's this trade-off between you're messing with my stuff and you're popularizing a game. There are lots of examples out there of games being resurrected from near death thanks to modifications to them. And they became a success because of the community, not the initial developer. If you're affecting generally speaking, I think, and again, Ben and others can weigh in on this one as well. The North American companies won't care about contact that doesn't affect the game, but if you're affecting the experience of other gamers, then you're likely barking up the alley of somebody coming after you. So I think, for instance, in 2010, Blizzard sued somebody who ended up reverse engineering World of Warcraft because they set up private servers so people could play WoW without payment. I mean, that one was, again, that was impacting users. The bigger issue, of course, is everybody's playing to see on that one is they created an ecosystem where they didn't have to give money to Blizzard. So, going back to my point about follow the money trail, if you do that, they will come after you. But, perhaps a more generic mod. And I mean, we've seen this with, weaponry, characters, skins, other sort of things that get built on top of that. And different developers take different views of whether that's acceptable. Again, I think in North America, it's that community view. Japan's an interesting one. It's more like it is art first. You're messing with my art, and I have moral rights in that art. And I want to be careful because that concept of moral rights is actually a legal point. Like if you create something as an artist, you may sell me all the rights to go and, commercialize, sell that, but unless we specifically have you disclaim it, you retain moral rights. So you may not like the fact that I did something with your art after the fact. And the most Canadian example of this that always gets used in IP classes throughout the country are a set of ducks that were sold as part of a mobile apparatus in the Eaton Center in Toronto many, many years ago. And one Christmas, the employees of the Eaton Center put a bunch of hats and Santa scarves on the ducks. And the artist was right pissed about what they did to his art. And they actually got an injunction against the Eaton Center, and they had to take the hats and the scarves and everything off the ducks. So that's an example of a moral right being followed in on, but it's important here. And, Japanese game studios will view it as art. Nintendo in particular, they will view their game as a whole as a work of art. So if you do something to unbalance the game, even if it doesn't seem to affect anything, you've unbalanced the art. They view everything as a new game. The other thing too is just a subtle point on, it's not a sequel, it's a new game. It's not Mario is treated different from Madden is maybe the way that I would try to conceptualize it. They view each new version of Mario as a different thing. It's weaved together with common elements and storyline, but it is not just a slap a build on top of it. So again, want to talk about that. And then a very quick one, and then we'll get into questions. I did include this, even though it's not video game development, IP for streamers, because I found this personally entertaining to get into. If you are a video game streamer, a Twitch user, for instance, there's not the law of, don't take this slide to suggest there's like the law of Twitch or anything like that, but some similar things. I mean, I think the biggest one that comes out of this is, there's this open question about who owns digital personas. And there's a lot of articles on this. And for anybody interested, just some simple Google searching on the concept of ownership of digital personas leads to some really interesting results. But I'll give you an example that's used a lot that isn't from the video game thing is Viacom claimed they owned Stephen Colbert, the satire character, after he moved over to CBS for the late night show. And they basically said after he left, nobody could be Colbert, like Comedy Central Colbert. Like they claimed ownership over that. Now, apparently Stephen Colbert took issue with that, but it was settled out of court. Nobody knows exactly what happened. But by all accounts, nobody can create, like even Colbert himself cannot create Colbert, the satire individual. And this gets into interesting questions around, like, if I actually create a persona, as so many streamers end up doing, like, does it take on a life of its own, and who actually owns that? Does it belong to the creator or the producer, the streaming website? And, where this really comes down to, there's a murky area on law, but it comes down to strength and following. If you have millions upon millions of followers, it's a competitive industry. We do not want to lose one of our stars from Twitch over to YouTube, for instance. We need to curate certain people within our ecosystem. So a lot of it does come down to, if you have a lot of bargaining power and you have the followers to do it. The other thing too with this is just if you are streaming, pick on Nintendo again, is watch for using certain things in inappropriate context. This was a case that popped up about a week ago. I saw is Nintendo is currently suing an adult entertainment influencer for using the name Poke Princess. They are not happy about the medium that Pokemon is being used within. So again, you can get more in trouble by depending on the the industry you're bringing this off as well. Little subtle point too referenced in here and since some of the notes is also watch about endorsements. We don't have anything explicit in our Canadian competition laws. That's where those reside about, disclosing connections between a brand and an endorser. But you can get hung out to dry for false or misleading statements at the behest of somebody on there. So there's a lot more information on the streaming side, but just given the time, I'll pause here because the back half of the presentation is focused on some other legal related issues, but we'll open it up. And if anybody's got any questions, chats.
Thanks,
comments,
Joe.
war stories. I mean, look, this doesn't have to be questions. If somebody wants to lament their lot in life.
No, I can't agree with you more. We will monitor the chat here and from our participants and see who's got any kind of calls.
We got one question already from Taylor, who says, everything about marketing games has to start early, showing prototypes, showing early work, etc. How does showing early work affect your game legally?
Yeah, so that kind of goes into the question of, I brought up that whole slide about protecting your ideas. And, if you're going to engage in any type of show and tell with other parties, I think it's a twofold approach. One, if you can get the party to sign some type of non-disclosure agreement, which I want to say isn't always the case. And I've had clients who make a mistake sometimes charging into rooms asking for that because some parties are just not going to play ball on that road. And that goes for, developer publisher parties as well as particularly investors. Most of them are of a class where they won't sign anything. They kind of take offense to the fact that you're suggesting that they would steal something by virtue of that. I think, the bigger part when it comes to conversations around confidentiality and proprietary information is just try to be incremental if you can. You don't have to give away all of the secrets if you can to entice somebody to partner with you. Take an analogy from my, mergers and acquisitions practice. When somebody's interested in buying a client of mine, we release information deliberately in incremental stages, particularly if it's a competitor. Because the worry, of course, is that even though everybody signed NDAs, you can't unsee things too. And that's another really important point. Even if you get an NDA, like somebody seeing what you did, you can't just blanket, Men in Black style somebody's brain after they've been in a meeting with you. So I think you really just need to be deliberate about what you're actually sharing out there. The other point that I'll just make too is that if you are in the midst of securing some type of formal registered IP and you're engaging in any sort of show and tell or other thing like that, be very careful because you can sewer your application by letting things leak out while you're in that process.
Got another one here for you, Joe, from Michael. Do mods need to be explicitly covered in a terms of use agreement, or are the protections we have as devs implicit?
Yeah, it's a good comment because terms of use are where it should be laid out. My theme on that slide was more of the interesting one that it's almost as if there's a convention around we deliberately kind of engage in what would otherwise be copyright infringement because the company has made peace with that fact. They are not litigious. The North American company hasn't outright waived its copyright rights and said full bore anybody can do whatever they want. They've just sort of recognized the importance of the community and the modders, and they let it slide as sort of like a waiver. But the undercurrent there that's important to also bring out is that they haven't formally waived it. They could wake up and change their mind on this. I brought up in the early point, when you're on the other side of it and you've developed a robust community, I think you owe it to your base to be very clear about what they can do. If you want to incentivize them and you want a robust community of modders, you should tell people about that fact. Some people, again, a not insignificant number of people probably don't care. And I made that comment about people don't really read terms of use. But, one of the comments that I didn't get into on this slide that's still up here with streamers is, terms of use can actually be quite important when we talk about whether you get kicked off a platform. I think Twitch right now is a 3 strikes you're out approach when it comes to copyright infringement. So it's, that's it. And I see Michael's, I'm more interested from the perspective of the original. Encourage mods for a game. We don't want people to do something with their games that could damage our company, game, etc. Yeah, and I think that I think that question just goes to, you want to be explicit and try to set out the contours of what's acceptable and unacceptable modding. I mean, we talked about, I use this example I was chatting about in the streaming context of Nintendo had a lot of problems with the use of naming in the adult industry, which again, can't really blame them, to be honest. So if it is something that could be damaging or offensive associated with this, a related analogy I might use on this is like, I've worked on a number in the past of social media influencer agreements. And one key part of all of those agreements are, if you're sharing content and it's adjacent to anything horribly offensive or that could be damaging to brand, then, we'll cut ties with the influencer. We won't pay them anything. We won't do anything associated with that because, we don't want to be, associated with Nazi propaganda or something crazy like that along the way. So I think it just comes down to clarity. I mean, again, Michael, the last point I'd make on that is some parties, like I said, they, on the face of it, they have their copyright, they have their IP rights, they have every entitlement to say, don't do this. And they just kind of let it go or let it slide. And, it becomes this kind of unspoken thing that this is acceptable, this is not acceptable. I'm a guy who likes more certainty than that, than just kind of vague, you're hoping that somebody doesn't pop out with a knife and stab you at the last minute. But I think you can lend some, some clarity to your community.
Okay. Good. And another one from Tim. Can I buy a Mickey Mouse doll and feature it in a video a player watches in a game? First question. I see this kind of thing in social media frequently where someone wears a Pokemon hat they bought, etc. Is this okay?
Yeah, so this kind of gets into, and we didn't talk about it because I kind of glossed over as part of it. So there are some protected areas, in the sense of if you're doing something for satire or, in some sense you're not making money off it or something like that, then it's okay. This kind of goes to like, I can run, a lot of games or other things in the background as I'm running a streaming operation or whatnot. And as long as I'm not trying to commercialize, or I'm not, in your example, as long as I'm not doing untoward things on the camera with Minnie Mouse, maybe Disney won't have any problem with that. And again, it's a game of enforcement too. Just kind of getting down to brass tacks. Look, a lot of my clients will make calculated choices. There may very much be a technical breach. I cannot, as a lawyer, tell you just blatantly breach copyright law, but I also live in a world of realities, and people do things, and they will, I don't think it's reasonable to go out in all cases where you happen to have something in the background and feature it. You can take this ad nauseum. Here we are sitting on, again, this is a presentation for educational purposes, so that'd be my fallback, but I got a Ninja Turtle in the background. He's been sitting here the whole time, and I have no earthly idea who owns the Ninja Turtle name, so don't quiz me on that particular point. But I also haven't done anything in this presentation that tried to leverage the good brand power of Leonardo here along the way, or have I made any overtures that I somehow own the copyright to the Ninja Turtles and whatnot. So that's part of it as well. Be careful about that's more on the streaming side, I think, because you just have some people who just create content at times and it's just more for fun until they actually strike it big one day. Maybe that sort of answered it. I know I meandered a few points there.
No, that's good.
Insight on retaining IP. Oh, sorry, I was just reading Alexa's question here. Any insight on retaining IP while using YouTube as a as a publishing medium. Again, this really comes down to reading your terms of use carefully, because I think everybody kind of gets this on the face of it. Until you're a very big deal, you have no negotiating levers. Like, you may read the terms of use on YouTube or Twitch and you may not like them, but you aren't getting them changed. So you need to be very, very aware of that. That trenches into the question of, once you actually become, something more than yourself, if I can use that, are you doing things like trying to assert your own IP rights? I mean, we talk about here on the slide that's still up here, there are some streamers who incorporate companies around their brand persona, which affords them certain advantages, liability protection being one of them along the way. They pursue trademarking of their screen name and whatnot. You're not going to win any wars directly, I think, against YouTube on this, but you may be able to take some actions of your own accord to protect yourself when you get up to a certain level. It's tough in the early days, because most people start a channel and maybe you get some traction, maybe you don't. It's kind of like catching lightning in a bottle of why somebody becomes a sensation or not. As a dad to a 4-year-old, I don't know how certain channels get 40 million views when kids do stupid stuff that they do, but hey, it's the world. It's part of it.
Alexis has posted one other thought. Any insight on retaining IP while using YouTube as a... Oh, I think you did this one. Yeah, sorry. You did this one, yeah. I don't see anything further, Joe. Do you want to continue into your second section there?
Yeah, let's go to section 2. So again, we do have, I had a whole section in here, non-IP legal issues. Look, and it's because, again, I don't know all the people in the crowd. Some people may be working within organizations. I'm doing this from the side of, look, you may be starting a company, maybe thinking about starting a company, and this presentation was first and foremost about the IP dimensions associated with video games. But if you start up a company, you're going to run into a number of different issues as well. We'll kind of hit on a few of these in turn. I'll kind of skim over a few and hit on some of the more important ones. There's a number of links throughout this for additional information as part of it. The first one here, dealing with human capital. There's a tie-in here. We were talking about this before. I was talking about protection. Protect your brain trust information. My second bullet point there, assignment of IP by workers. And, it's both. The big thing there to keep in mind, I think, is that most people understand, look, if I go out and I hire somebody, and actually the default proposition under most areas of law is that if I work for Ben and I create something for the company or for Noodle Cake, it belongs to Noodle Cake. That is a different proposition with contractors, and why you need to have specific terminology in your contractor agreements. But you're usually safe on that side. But the more interesting one is, me and Ben and Darcy get together and we think on a new and great idea for a startup, and we haven't incorporated anything. We've just been having random weekly get together drinks and kind of spinning ideas and doing all this other stuff. And then someday, 6 months down the line, we finally say, hey, this is good. We're going to proceed on this. I'm going to get the company set up. We're all going to own a third of it, and we're going to actually pursue this. It's a real thing now. Pause for a moment and recall that I might incorporate a company today. November, I don't even know what day it is anymore, COVID, November the 12th. And we might have been talking about this since January 1 or, March 13th. Maybe let's say, during COVID, we decided we'd start a business like a lot of people. The inception of ideas went back to March. And it's actually very important when you start up a company for your initial founders to make sure that they assign their IP over to that company once it gets incorporated. Because there is not just a general presumption that happens. And that is not a complicated agreement, by the way. I mean, you can have longer ones. The one I generally use with my founder clients is all of 3 pages, but it basically just says any ideas we had associated with this business in a kind of broad descriptor now belongs to, Sweet Game Development Corp or something like that as of the date of incorporation. And that's important. Think of it like chain of custody. And it becomes very important when you get into raising capital or you get acquired. And I still remember this in 2018, back when you could go to events. I know that was a thing back in 2018. You could go to large scale events on cool islands in Montreal. And I went to an event called Startup Fest, which, when the world goes back to normal, if anybody's interested in tech or startup life, it's one of the best events in Canada. It's always held in Montreal. It's very fun. And one of the speakers was the woman at the time in charge of acquisitions for Facebook. And she was sort of asked this question of, what's the most common deal killer when we get into this? She said, lack of IP ownership. The number of people who didn't firm up a chain of custody on their intellectual property for their startup before Facebook came in and wanted to buy them had sewered, like, based upon the way she worded it in her expression, sewered a lot of deals. So there were a lot of people out there who would have made a lot of money, because they don't tend to buy companies for next to nothing, had they sorted things out. So you don't want to find yourself in that situation. I talk on this slide as well about incentivizing people. Look, the best form of currency for startups in my world are giving them stock options in a company. That's typically the way we incentivize if you don't have any particular money. The key point that I'll just say on that is there are general rules of thumb. Don't give away the farm right away. It may be great and you may feel wonderful that you attracted people to work with you on your very cool startup, but that does not mean you should automatically give them 25% of the company immediately on day one. A very common thing that we talk about in the tech world is something called a 1-year cliff, 4-year vest. And what that would mean is that if I gave Ben 100 shares in my startup, and doesn't matter what that percentage is, if he continues working for the startup for a full year, he will earn 25 of those shares, free and clear. The next 36 months after that 1-year period, 4 years in total, he earns another 1/36th of the remaining shares on a monthly basis. Could be quarterly as well, just depends on convention, as long as he sticks around. The key point is, if he falls off the journey and leaves the company at any point, he loses all the unvested ones along the way. So it is pushing people to continue on the journey. The worst thing you can have, that I've seen when you go to investors and you present to them what we call your cap table, your list of who owns what in the company, is they go, why is this Ben Schmidt guy on here? Like, he wasn't at any of the pitch meetings and seemingly doesn't work for your company. And then I have to tell this sordid tale of how we were friends and we got into business together, and then we did not see eye to eye at all on things. And he was summarily tossed out the front door like the Fresh Prince of Bel-Air by Uncle Phil. And things ended badly. And then they say, that's fine, but he still owns 25% of the company. That's kind of a problem. So just questions about, that's more of the theme, is don't give away the farm too early. Founder rules of the game. This just becomes important. I keep using this example, I'll keep playing on this example as we go. The Joe, Ben, and Darcy started a company. We're still in good stead in this example. So we need an agreement. Like, what happens if one of us gets, hit by a bus, which, hell, given the weather out in Saskatoon, is pretty likely at this point, if you were stupid enough to go walking. But you need to have an understanding of, or decision making. I mean, if there's just 3 of us in the startup, like, how do we determine fundamental matters? What if we don't agree with the direction the game is taking? Is it majority rule? Like, is it 2 out of 3? Or are certain decisions so fundamental that I need unanimous agreement among everybody? That's a big point. One of the biggest ones we get into, it says shareholders agreement there, is what if somebody comes in with a big bag of money and wants to buy the company? So Ryan's sitting out there and he's got a giant bag of cash and he says, I want to buy out your guys' company. And, me and Ben think that's good, but Darcy doesn't think that's a good deal. Can we force Darcy to sell because it's 2 out of 3 of us? Is that unanimous? Is there some other threshold along the way? Those are questions you're going to have to wrestle with. The other thing too is we may, as the 3 founders, subject ourselves to vesting like employees do. I reference it in there. I will say not as common in the Saskatchewan market to see true founders subject themselves, but very common in, tech mecca in the Bay Area to see, in a 3-founder situation like the one I'm describing, we've all agreed to that kind of schedule where if I drop off after the first year, I get nothing as part of it. That can seem pretty harsh, but it's to prevent, having me as a dead weight on the cap table if Ben and Darcy are the ones doing the heavy lifting going forward. So you got to consider that. I do provide some, again, I'm going to put a disclaimer on this. Always talk to a qualified legal professional, but I am a pragmatic person, and a lot of tech and business incubators provide half decent libraries of legal documents if you're really struck for looking for things in the early stages. I will use this unabashedly to plug the McKercher Startup Program package, which deals with incorporation and organization of your business, all of the documents we're generally going to discuss here tonight, as well as one-to-one advice, 1 to 2 hour strategic meetings for the first 6 months of engagement. And I only charge $1,000 for the whole thing. So we try to make it a compelling offer so that you may choose to retain me as opposed to go and grab documents off the internet. So please consider that. But key point is having agreement on these things. The next slide, raising money. This is again, this could be a whole 2 hour conversation in and of itself, but there are ins and outs of how to raise money. Going back to even that last point on the slide is even just how do you build a presentation? I can give you a hint. It looks nothing like what I'm presenting here, because if I put this many bullet points and this much information on a true pitch deck presentation, I'd get kicked out of a room. Unless it was actually about nice traction stats about how much money I'm making or something like that. So there's kind of an art to pitching your business idea. So I do encourage people to look at that pitch deck. For those who don't know, Y Combinator, by the way, is kind of regarded as the best tech incubator in the world, conveniently located down in the Bay Area, San Francisco. This is more just a point of, be aware you may need to take money from people at some point, and you have to kind of decide whether or not you even want to do that. The nuances around taking money, the different forms of, that you can take capital from people. The key point is you are giving up ownership. And, if me, again, in our Joe, Ben, and Darcy corporation here, we may start with a 33% interest each. But if we bring other people to the party, pesky old math makes it so that we reduce ourselves from that 33%. And you may have to make those compromises over time. I mean, that'll happen both with investors and with employees. Again, there's some good documents here. That link there, by the way, for the National Angel Capital Organization, it is to some common legal documents you see for raising capital, but there's some great resource material there. So if you are curious about, like, how do I raise money from these people called angel investors, there's some good stuff in there to give you a primer. And I think they really do strive to build it in a plain spoken way. Unfortunately, there were a bunch of lawyers who weighed in, and there's a few points in it where it gets a little murky, but we can't help ourselves at times. Other key point talking about raising money, know your grants. There are grants all over the place. These are just a small sampling of different grants that you could access. Grant money, non-repayable government funding is wonderful. Money to accelerate your business does not dilute you, and in some cases you may not even have to repay if certain things are met. The middle one there that I referenced, this technology startup incentive, this is a tax credit that has existed in Saskatchewan for a little while. People who invest in early stage tech companies, innovative companies, they get a 45% tax credit for the amount of money they put into a startup. So this has had, if you talk to Innovation Saskatchewan that has administered this, they will say this has made an appreciable difference on this. There's some nuances and a rundown on it. Conveniently, some guy wrote a blog post on this, and I've included that guy's blog post for public consumption for you if you wish to read on it. Another one too are you hear a lot of tech companies talking about this scientific research and experimental development credits. These are basically tax credits that the federal government hands out for engaging in innovative research, rethinking things outside of the box. Some of it tends to get focused on patent application style changes, but they have handed out shred claims for software related startups as well. It's a common thing. Ben wants to weigh in on this.
Noodle Cake used to get shred money.
Yes.
We don't anymore. I don't, due to some technicalities, but we used to be eligible for it and we used to get it. So
yeah, and And the big key for everybody with SR&ED is that a lot of tax credits will watch for the word refundable, non-refundable. Non-refundable just reduces whatever income tax you might have down to zero, which, let's face it, if you're a startup, you're probably not paying income tax anyways because you're not making any money. So you would love something to be refundable so that when you, quote, go below zero, they might actually mail you out a check on top of it. So that's why a lot of my clients love SR&ED. They actually end up with money at the end of the day. But it is nuanced, so be careful with that. And I provide some links there. Privacy. Oh, sorry. Go ahead, Ben. Yeah.
It's like if in terms of getting funding for your project too and stuff. Last week's talk by Jason talked a lot about this kind of stuff, and I know that they're going to be hosting that online sometime. So if you missed that one, go back and check it out if you're looking for more about funding in games.
Yeah. Awesome. Oh, thanks, Ben. And I mean, I would just wrap on this one by saying this is another one of those homework points. Like, there are all sorts of hilarious, weird grants out there for all manner of things. I sometimes think of, like, back when I was in, it was grade 11 or grade 12, and my dad would harp on me to go look up like every weird essay writing thing to get like scholarships so that he wouldn't have to fork up any money so I could go to university. And again, he wasn't wrong. Like, you go on the internet, you can find any number of weird things. I wrote some strange essays to get money. But you know what? If you don't look, you'll never know. And you wouldn't want to pass up, particularly when we contrast the grants versus the equity ownership. It would really suck to give up 10% of your company when rolling up your sleeves and maybe writing a good proposal could have got you the money you needed. And my final comment on raising is be deliberate about how much money you need. There is such a thing as asking for too much money. But I know a constant theme we run into now when I have clients thinking about raising capital is how much runway, how much cash to move along the way do you need for the next, usually we'd say 12 to 18 months. We've actually seen that extend out in COVID times to 18 to 24 months. That's just a response to risk aversion and the uncertainty out there, but just be aware of that. Protect your data. One way or another, you're probably curating people's information. So you should be careful about that. Be very careful if you're curating the data of any Europeans or people from California. There are much more robust requirements that I can't adequately speak to as a Canadian lawyer, but there are different levels of requirement. The good news is I don't think anybody in this call would be dealing with anything like health information and whatnot. We're not talking about any health tech related companies. Maybe, I mean, I know Noodle Cake's other spinoff is probably dealing with those issues very much. But there's kind of and I reference a few here. In Canada, we have this piece of legislation called PIPEDA, the Personal Information and Protection of Electronic Documents Act. Certain provinces have their own version of it as well. So privacy becomes this. Privacy law is actually a really oddly convoluted thing in Canada because certain provinces have their own rules. And the federal guys basically say, as long as the province has rules as good as ours, we'll let the province set in place the rules, but if they're not, then they got to use the federal ones. So like here in Saskatchewan, there's federal PIPEDA, and then Alberta's actually got its own version of PIPEDA. So this can be provincial, which is kind of annoying. The Privacy Commissioner of Canada, which is listed here, I think has tried for years to create a unified approach to this, because I would argue, sell me on the compelling reason why my brother's data in Vancouver is any different than my data in Saskatoon. Maybe we should all have the same protections and whatnot. I provide that link. Again, privacy could be a long conversation. The reason why that link particular, there's a lot of information on the Privacy Commissioner's website, but that is the for businesses section. And I do actually think they have spent a lot of time trying to like build in easy to follow and kind of plain English rundowns on how to observe your privacy obligations as a business. And you can actually go so far as building out a privacy plan or strategy if you navigate through that section of the Privacy Commissioner's website. So it can be useful to spend some time in there. And privacy is an important thing. I mean, it used to get kind of sloughed off to the side, but I think consumers care about it. And I think people are starting to wake up to the point that it might make a difference. I was listening to a podcast last week where somebody pitched the idea of saying, well, we might never ever get Facebook to actually truly abide by people's privacy rights. But what if you gave people a choice and said, if you pay $5 a month, we'll basically give you incognito mode across the board while you're surfing through that. And a bunch of venture capitalists who are on the podcast were like, maybe people would pay $5 for, that privacy dimension. I know, and I don't have a great handle on this. I know I have heard stories that Apple is trying to approach this from the hardware side by limiting access curated on your iPhone to certain pieces of software. So they're actually, I think, trying to buck the trend of every tech company is awful and trying to curate your data, but they're approaching it from the hardware side of things.
Google as well, real quick. Yeah.
Sorry?
Google as well on Android and all that stuff too.
Of course. Yeah. And then, I mean, at a baseline, if we're talking about like, what do I actually need to do? I mean, the baseline thing you should probably look at is, a privacy policy in terms of service. That's kind of the floor of where we start with that. That link will seem weird for me to be providing. It is to a site that generates and creates privacy policies in terms of service for a fee, which is kind of what we do. But I have had clients use it, and quite frankly, what it spit out wasn't bad. And it's actually not bad because it also has some good tie-ins if you check boxes and say, I actually do have users with residency in California or in the European Union and other stuff like that. There's no substitution for proper advice. But again, as a startup lawyer, we make concessions at times. And I know there are products out there that seemingly eat into my traditional line of work. And it's easy for me to just sit here and take the standard lawyer position of everything and anything that has to do with legal, you must go through me. But there are options out there and the world's changing. And I think it's incumbent on me to, provide options to parties when they want to look at that. That last one are just some resources on data security. I actually really like, and I can tell that it was well received because it got probably more likes and shares than anything I've ever shared on LinkedIn before, was this SaaS CTO security checklist for companies. Again, may not be perfectly relevant in the video game thing, but the reason I liked it is here was somebody who put this article together thinking about security from a stage of business perspective. Because the biggest problem you run into is you start reading down this thing and you're like, man, there are all these crazy levels of data security, these weirdo terms like SOC 2, and I'm just a startup and I don't have any money for a robust security apparatus. This at least attempted to say, this is the stage you're at. This is probably what you should concentrate right now. As you grow, we will insist on it as well. And my last comment I'll just make to maybe give everybody a little more comfort after we scared everybody about collecting data is, privacy and even data security tend to be principled based, at least in North America, versus hard right based. So they can scale with a company. You as a startup are not expected to have the same privacy apparatus as, Farm Credit Canada or EA or somebody or some larger incumbent. Once you get to a certain size, there's an expectation you're going to adopt more robust apparatus. You're also going to be collecting a hell of a lot more data at that point. But the big point to remember, if you remember nothing else about privacy, is informed consent. If you take my data, I better damn well know what you're going to do with that. And if you wanted to go to a European style level of compliance, you'd get my specific consents to usage of every piece of data you curate from me. And I will specifically know exactly what you're going to do with that information. That is not the hard and fast rule right now, but it's important to watch trends, and we have a little bit of a trend in that direction.
If I could just add real quick.
Yeah, go ahead, Ben.
In particular, as game developers, make sure that you know what data your plugins and your integrations are collecting, specifically analytics tools and ad networks if you're working in mobile in particular. When GDPR hit, there was so much stuff that had to be disclosed, and it's scary how much stuff they were collecting without us like trying to be malicious, without us as game developers doing anything. There's a lot of data being collected that you need to be aware of. And just one other quick law, if you are making games that could appeal to children, look up COPA in the USA. We have a company that we work with called Retro Dreamer. We published their game Happy Jump way back in the day before I even worked at Noodle Cake. They got hundreds and thousands of dollars worth of fines because they were collecting too much data in a game that decided that like they said appealed to kids, because it's a pretty kid friendly game, and so the ad networks were collecting too much data. It didn't abide by COPA, and they got honestly hundreds of thousands of dollars worth of fines. So be aware of that.
Yeah, that last one is a great comment. I mean, I think it's one of those things that hopefully should be apparent on the face of it. If you're dealing with minors of any stripes, there's probably separate legal framework and obligations associated with it. So, just be mindful of that.
Well, and the thing about that one in particular is just because your game, you can say, oh, no, my game is for 13 and up. But if your game is too cutesy and appeals to kids too much, then they can say, well, no, like this is a kid's game. It's for kids. You broke the law. So.
Yeah. This is like where you need to maim the jelly belly that you're playing, some Candy Crush iteration on or something like that, so that the kids won't. Anyways, getting organized. I'm gonna, just the interest of time, because we're bucking up against it, I'll leave that one in the slides. Again, incorporating your business is pretty rudimentary. There's some decent resources there and whatnot I won't get into. Going global, we talked. We chatted about this. Look, Ben just brought up a good point. You're bucking up against U.S. related laws very quickly. You're running up against European related laws, so you have to kind of be aware of some of that stuff. Immigration, complicated area. Don't have time to address it in 1 minute. But if you're going to bring in, the reason I have these ones on this slide, by the way, is I know in consistent surveys of technology companies, innovation companies here in town, the number one problem seems to be talent and hiring local, like skilled labor along the way. And we're a great place to live, but unfortunately, every now and again, we get snowfall craziness like this. We're not a hugely populous place, so attracting people in is important. And of course, as you can anticipate, there's some complex rules around that. Not insurmountable or whatnot. Quick plug for a great organization on the West Coast called Van Hack that helps a number of organizations across Canada bring in skilled labor, employees, etc., in the tech sphere. Tax. Again, this is another longer conversation. Suffice to say, if you may or may not be selling into certain countries and whatnot, you may get pulled into the tax dragnet of that other country. So, thankfully, a lot of states, for instance, they do adopt kind of, you have to reach a certain threshold of sales to people within that state before they'll start dinging you with things like local state taxes or having to pay, some level of income tax in that state. And that's kind of generally been adopted. Europe has floated with this as well, and that until you reach kind of a certain threshold, we're not going to bother going after you. And again, being frank and kind of practical, I have clients who will go, straightforward into the U.S. market and then just throw up their hands and say, if we get dinged, we get dinged. We can't afford to pay a lawyer in every state. Sorry. Again, can't advise you to do that, but people have been known to do that. Exporting goods, won't get into on this one. That last one too is just an interesting study that tries to get global data on startup ecosystems. And what I find really intriguing about that particular study is they go out of their way to say, if you're interested in artificial intelligence, this hub within this country is the one that seems the most promising for building startups associated with that. Right now, interestingly, that's Edmonton. Montreal's farther ahead on that, but Edmonton's actually got some companies on that. But just an interesting one. I've shown this to a few people in the tech sphere. There's a few people whose goal in life is to actually get Saskatchewan to blip on that, because it's one of those lovely maps where we don't exist. So it has every other city, but Regina and Saskatoon seemingly don't exist in that study. So hopefully with innovative companies like the ones on this call and other people, we'll change that. It's part of it. And my last point is just about, look, we talked about a bunch of legal stuff. You may at some point have to hire somebody like me, as awful as that sounds. So you should understand things about the legal market. Like, traditional lawyers love an easy way to charge people by the billable hour. I am a fancy lawyer with large overhead in a nice building on the riverfront. So my hourly rate has to be $750 an hour, or I cannot exist and own my house in the Willows. So this is you can tell I really like all my colleagues, peers. Sorry, but you can push back on this. You can be a discerning customer if you're presented with something. There is a push to more certainty when it comes to pricing. Ask for fixed fee examples. If it's not something that's convoluted, and you're talking to a guy or girl who says they're a partner, there are associates. We have layers of people within a firm who are just as qualified to do things. And quite frankly, you should be counting on the person to allocate it to the best use for what's required. I work with a team of associate lawyers and students. If it's something simple, it's not a knock. Don't view it as me schluffing you off to somebody, but I will delegate and I will make sure they create the product, bring it back to me. I mean, people who work in teams understand this. Everybody has a role to play. Documents are another one too. I mean, you saw maybe something that you don't normally see from lawyers. I provided links to sites that'll do document generation and templates. Part of what I've seen as part of my own offering is sometimes a template will do just as well in the circumstances as something that is completely tailored for what you need at the point in time. It's better than nothing. Employment contracts are a good one. We've got a pretty robust template that just requires some naming and duties and responsibilities and some other basic information filled into it, versus paying large oodles of money for one that is specific to every single hire, which I dare say you probably don't need there. Market knowledge matters. Clearly, it's better to hire somebody who's in the tribe, in the know, understands it. Legal's a very important part, but understanding the market norms is just as important. You head into a negotiation with another side and there's just some well understood thing about, I don't know, allocation of profits we were talking about publisher contracts or something like that. It'll save you time and money if your advisor actually understands the norms out there in the ecosystem versus somebody who has no idea. But I will give a nod to, look, everybody starts somewhere too. So maybe you find somebody who's at least interested. And the reason I put that in there is you always get this slide that says hire the most experienced person you could get. I started off 3 years ago as a guy who was tangentially related to the tech community. Somehow, by dumb luck, I have found myself representing oodles of tech companies along the way. And I just hung out. I listened to people. I got involved. I asked people what I should be reading and blogs to follow, podcasts to listen to, all this other stuff. And I really tried to get myself into the tribe. And, if you can't afford the person who's done every deal on, in a particular geographic sector or something, it costs a ridiculous amount of money, maybe the next best thing is somebody who maybe had a background before they became a lawyer, or they just seem really engaged and interested to learn on that. They shouldn't charge you for their learning, to be clear, but that's just another point there. I won't get into legal technology. Suffice to say, there are things we can use behind the scenes to speed up how efficient we are. And, you may ask that question. And if the answer is, well, I use Microsoft Word, you may be disappointed with that answer. And blogs, there's lots of information out there. We provide a lot of great info. Other places provide lots of great info, ending with do your homework. And my final thought, this is repurposed from why do you hire advisors? So you don't blow yourself up. That's really it. I used to have the slide. I keep alternating doing the presentation between where it's full of just minds and then the ones where it's all flags all over the place. You pay people to identify things. And if you take nothing away from this presentation, is hopefully you can do a little bit of that flag identifying, because you may be the only person out on the minefield that is the startup when you begin your journey. You will eventually bring on advisors and other people who will help you put out those flags, so blow yourself up along the way, and that may help you with the journey. But understand some important thing about any new business venture. Despite having all of these people with all their expertise, much like Minesweeper, you may still blow yourself up and fail, but that's part of the fun. So I encourage everybody, startup life is a fun life. It's a chaotic life and a crazy one, but it is not dull by any means. So with that, I will And
There, no, you did good. There is, we'll open up, we got let's take a few minutes here. We got a few Q&As that we can walk through here. There's another one here for you, Joe, from Michael. We have a game that encourages players to create and share custom content. This content is often comprised of media that the player don't actually own the right to share. We don't directly host, control, or distribute this content. Even so, do we need to be mindful of even acknowledging it exists? And in brackets, when there's a blatant copyright infringement.
Yeah, and I think the short answer to that one, Michael, is yes, you do. I mean, it's hard to say whether there's a hard obligation in that case, but I mean, you can take cues from, my earlier conversations where I talked about some of the streaming websites like Twitch, where, they adopt a policy. Look, if we catch you 3 times using copyrighted material, we're going to boot you off the site. And I think most actions would be directly against the party using the content. But the difficulty you have, and this is kind of the wild west of legal actions, is we see at first instance a lot of the times a kitchen sink approach. The aggrieved party sues everybody that was associated with it. You might fall off in the scheme of it, and the people who are actually engaging in the copyright infringement might ultimately be the ones who have to bear all the pain, if I can use that term. But you still don't want to have to get dragged through the mud at first instance getting sued. And it's just nicer to at least be in a position where you say, we take some efforts. I think as you grow beyond a certain size, it becomes impossible to police almost everything out there. But it's better that if you did find yourself on the business end of a copyright infringement claim, to be able to at least point to, look, we had some safeguards in place. I could make a similar theme when we talk about data privacy. Again, nothing's perfect. You may be subject to a breach event. Yeah.
Well, there wasn't no other ones, no other Q&As there. I cleared it off. Is there any further questions that you want clarified, or does anybody have anything that they want to ask Joe? We can always take it offline.
I will actually put up I'm sure it's on the slides, but if anybody wants to get in touch with me, you've got that, or it was on the first slide. Darcy's favorite way of getting in touch with me, Twitter, where if you want to read about me making edgy / disparaging comments about the legal profession, you too can come on to Twitter.
Yes, Joe. Yes, I then I realized that your secretary told me to go and send it to his email.
Yeah, that's more my bad. I had this. I don't know. It was about a year ago when I was reading a thing about notifications and draining attention from day to day, and I went on my phone. I turned off all my social media notifications, so I don't even get pinged when people send me. Again, I try to check them regularly. I was a little behind on Twitter, so that's fine. But it was more of just a look. Facebook's a good example. I joined in for a specific purpose. That thing doesn't need to run my life. I will decide when I want to look at, pictures of my friends' kids, because I am my social group is consisting of nothing but people who have children. So it's nothing but like pictures of people with kids.
Right on.
Anyways.
Good stuff.
Yeah.
There is no more questions for there, Joe. And so I think what I'll do is, in closing, I'd like to thank Joe for your awesome insights and expertise there in IP law. Very well done. Thank you very much. Would also like to thank Ben and Ryan tonight as well for keeping us within the 2 hours here, and that's the best way to wrap up a really good presentation. As everyone knows, this is our 5 workshop series that's sponsored by SaskTel. So next week's webinar is on pitch to publishers, delivering the perfect game project pitch. That's going to be presented by Jason De La Roca, and that's held next Thursday, the 19th of November, and that's still 7 to 9 p.m. Ryan has posted up the link there. If anyone's interested in attending that workshop, that should be another interesting one. Joe touched on a few pieces here tonight. So please sign up. We're also going to be having mentorship with Joe. So we'll have an application process to get a 1 hour session with Joe if anyone is interested in it. Ryan has also posted the application form for that as well, to have a one-on-one mentor with Mr. Gill, and that's another piece for us to kind of close off here with is that. If there was no questions, Ben, did you have anything that you wanted to add? Any more anecdotes, or are you?
I kind of squeezed them in as we went. Yeah, I know that personally, my legal hell has been with privacy laws, but I think everything that Joe said here was just really important. I'm really glad to have heard it, and I think good job.
Right on,
Thank
yeah.
you. Appreciate that. Again, it's like I said, if anybody walks away with some takeaways, or, if at minimum, I have prevented you now or in the future from falling within a pit of hell, then I will walk away satisfied. So.
Well, we don't want that.
No.
Yeah, but you did well, Joe. Thank you very much. Thanks again, Ben, for co-hosting, Ryan for running the background show there with links and keeping our chat active. And on that note, I'll end this webinar and wish everyone a safe evening tonight. And thanks again, Joe, for your time.
Perfect.
Hey, everybody.
Bye, everybody.
Thank you all.
See you next week.